Welcome to our channel. Today, we will look into buying land in Ghana. Purchasing land in Ghana has become increasingly complicated, with many individuals encountering challenges in the process. At NewBlacksGhana, we have taken it upon ourselves to thoroughly investigate the legal requirements and documentation necessary for acquiring land in Ghana. Through our research, we have identified the only authentic and valid documentation and procedures that anyone, whether Ghanaian or foreigner, must follow to ensure rightful and secure ownership of land. Our step-by-step guide outlines the essential processes to avoid common pitfalls and protect your investment. By following these procedures diligently, you can confidently navigate the complexities of land acquisition in Ghana and secure your property without worry. Let us guide you on the right path to achieving your dream of owning land in Ghana. This isn't just any video. It's packed with valuable and essential information. Take your time to watch it from start to finish, and don't miss a detail. Feel free to take notes and screenshots or save key points on your phone. If you're serious about buying land in Ghana, this video is a must-watch and will provide you with everything you need to make informed decisions. Let us get started. We will start with this question. What is conveyancing in land registration in Ghana? Conveyancing refers to the legal process of transferring ownership or interest in land or property from one party to another. In Ghana, this process is critical for ensuring that land transactions are valid, transparent, and recognized by law. It involves several stages and must comply with the relevant legal frameworks, including the Land Act 2020, Act 1036, and other regulatory provisions. Key aspects of conveyancing include the preparation of a sale agreement and the due diligence and land search. The sale agreement outlines the terms and conditions of the sale, including land details, price, and conditions. Due diligence involves verifying land ownership with the Lands Commission, ensuring the title is free of encumbrances. Searches may involve the Public and Vested Lands Management Division, Survey and Mapping Division, and Land Registration Division. Drafting and executing a deed of conveyance is crucial. This legal document transfers land interest to the buyer, including details of parties, land, and signatures, typically drafted by an experienced property lawyer for legality. Stamp duty must be paid to the Ghana Revenue Authority to validate the document. Registering the land with the Lands Commission is the final step. This process secures the buyer's recognition as the rightful owner and protects against disputes. Required documents include the deed of conveyance, approved site plans, proof of identity, payment evidence, and fee receipts. A land certificate is issued post-registration, serving as proof of ownership under the land title registration system. Conveyancing is vital in protecting the buyer's legal rights to the property. It prevents land ownership disputes, ensures compliance with Ghana's land laws, and secures the buyer's investment. Engaging a qualified lawyer for this process is advisable to avoid costly mistakes and ensure a smooth transaction. In this section, we will look at types of interest in land under Ghana land law. The first one is the allodial title. It is the highest form of land ownership in Ghana, held by traditional authorities or the state. It represents ultimate ownership, with other interests like leasehold or freehold deriving from it. Individuals can't hold allodial title, but can acquire usage rights through agreements with title holders. The second type is freehold, which has two forms. The customary or common law freehold. Customary freehold is held by individuals or groups within a traditional community and is inheritable. It offers perpetual interest as long as customary rules are followed. Common law freehold, similar to customary, differs in acquisition. Strangers and community members can obtain it, but the 1992 Constitution restricts it. It's a similar perpetual interest, but arises from agreements between landowners, making it non-exclusive to community members, but restricted to non-Ghanaians. Leasehold is a temporary interest in land, typically 50 years for non-Ghanaians and 99 years for Ghanaians. It involves annual rents and covenants with rights and obligations during the lease period. At the lease end, the land reverts to the lessor unless renewed. Lessor interests include sharecropping and tenancy agreements. Common in Akan areas, agreements like Abunu and Abusa or local dialect terms vary. These grant limited land use rights, often agricultural, and revert to the original owner post-agreement. In this section, we will talk about leases in Ghana's land law. A lease is a fixed-period land interest with specific commencement and expiration dates. Leases in Ghana typically are 99 years, but terms are negotiable. Leases beyond 99 years are rare, with 50 years as the maximum for non-Ghanaians. The lessor grants and the lessee receives the lease, establishing a landlord-tenant relationship. Essential lease features include a defined period, exclusive possession, and essential contractual elements such as the parties' names, duration, renewal terms, and payment considerations. These ensure clarity and security for both the lessor and lessee, outlining all required details for the lease to be valid. Ghana's land ownership types include stool or skin land, owned by traditional authorities, family of clan land, held by families, private land, individual ownership, state land, government managed with formal applications, and vested land, government held on behalf of traditional authorities. Each type has specific ownership and transfer requirements. Now, let's look at the procedure for registering a land bought from private owner. Negotiate with the owner, prepare and sign documents with a lawyer, and submit to the Lands Commission. Site plans endorsed by the owner and applicant, certified by a licensed surveyor and regional surveyor, and witnessed by principal elders are required. Submit documents and await approval. Registration should also have the applicant's witnesses provide full details and submit documents to the Lands Commission. Pay processing and registration fees. Documents are processed and stamped at the Land Valuation Board. Get tax clearance from the Internal Revenue Service, register at the Deeds Registry, and receive the original copy. For stool or skin lands, negotiate with the chief, prepare documents, and submit them to the Lands Commission. Attach site plans to each document copy, endorsed by the chief and applicant, certified by a licensed surveyor and regional surveyor, and witnessed by principal elders. Submit documents for approval. Registration should also have the full details of the applicant's witnesses. Then submit documents to the Lands Commission, pay fees, and await processing. Once processed, documents are stamped at the Valuation Board. Obtain tax clearance from the Internal Revenue Service, register at the Deeds Registry, and receive an original copy. Pay the first year's ground rent. Purchasing family or clan lands. First, negotiate with the family head and principal members for family or clan lands, prepare documents, and submit them to the Land Commission. A solicitor of the Supreme Court must sign the back of each copy. Attach site plans to document copies endorsed by the family and applicant and certified by a licensed surveyor and regional surveyor, witnessed by principal elders. Submit documents and await approval. Registration should also have the full details of the applicant's witnesses. At least 2 principal stool elders, with status, must sign as witnesses. Then, submit documents to the Lands Commission, pay fees, and await processing. Once processed, documents are stamped at the Valuation Board. Obtain tax clearance from the Internal Revenue Service, register at the Deeds Registry, and receive an original copy. Pay the first year's ground rent. To buy state and stool-vested lands in Ghana, the process starts with applying to the Lands Commission for a plot. You will be invited to complete the application form and questionnaire with 2 passport-size pictures. If approved, you must pay requisite fees and charges. The Secretariat of Lands Commission will prepare the documents, and you will be invited to execute them. Next, the executed documents will be signed by the Chairman of Lands Commission. You will need to pay ground rent and registration fee. The documents will then be released for stamping at the Land Valuation Board. You must obtain a tax clearance certificate at the Internal Revenue Service. After registration at the Deeds Registry, the original copy of the document will be given to you. This section will talk about the Land Commission requirements for registration. But before I start this section, let me explain what the term state land second transactions. In the context of Ghanaian land law, state land refers to land that has been acquired by the government through legal processes such as compulsory acquisition under statutes like the State Lands Act, 1962, Act 125. This land is managed by the state on behalf of the public and is typically used for projects or developments in the public interest, such as schools, hospitals, or infrastructure projects. The term state land second transaction typically refers to situations where a subsequent transaction involving state land occurs. This can happen in three contexts. 1. Reallocation or regrant. The government may reallocate or lease the same parcel of land to another party after the expiration of an earlier lease, or when the first allocation has been canceled for non-compliance with the terms. In such cases, the land is subject to new terms and conditions. 2. Subleasing by initial allotees. If an initial grantee or lessee of state land subleases or transfers their interest to a third party, this could be referred to as a second transaction. However, this would usually require government approval to ensure compliance with lease conditions. 3. Reconversion or reverse transfers. If a parcel of land acquired by the state is no longer needed for the intended purpose, it may be returned to the original customary owners or reallocated. This process, though very rare, could also be termed a second transaction, depending on the context. 1. For state land second transactions, the requirements include the date and nature of the instrument, and the particulars and signatures of parties involved. Additionally, for illiterate parties, a jurat is needed, along with the stamp duty and an oath of proof. All these must meet the standards set by the Land Commission. It includes the necessity of the solicitor's stamp, supporting and recited documents, and an approved plan. There should also be consent for subsidiary transactions and endorsement of site plans by both parties. Forms of identification for the owner or agent, ID, passport, are required, and the site plan should predate the document. The schedule must be checked against the site plan. 2. For stool land second transactions, you must provide the date and nature of the instrument and particulars of parties involved, including their signatures. If parties are illiterate, a jurat is needed. Additionally, the instrument must bear the stamp duty, an oath of proof, and the solicitor's stamp. It includes ensuring the solicitor's stamp is on the document, supporting documents are correctly recited, and the approved plan is attached. Additionally, there should be consent for subsidiary transactions, site plans endorsed by both parties, identification forms, ID, passport, and the site plan should predate the document. Ensure the schedule matches the site plan. 3. For deeds registration, the date and nature of the instrument, particulars of parties, telephone numbers and emails, and signatures of parties are required. Accredited signatories must validate it. The instrument should include the stamp duty and an oath of proof. It includes the solicitor's stamp and supporting recited documents in the process. Attach an approved plan and ensure both parties endorse site plans. Consent or concurrence is necessary for state and stool lands. Cross-check the schedule against the site plan and seek planning approval for concurrence. 4. For title registration, it requires providing the date and nature of the instrument, particulars of involved parties, and their signatures. Also essential are the jurat for illiterate parties, stamp duty, and oath of proof. Further requirements include supporting documents, an approved plan, consent for subsidiary transactions, endorsement of site plans, identification forms, ensuring the site plan predates the document, and verifying the schedule against the site plan. 5. For stamping processes, identify the type of document, Check the customer's purpose and verify the date. Check names of parties and addresses and confirm consideration, rent, term, and commencement date. Note the job number from the SMD. It includes checking the site plan against the schedule. This involves verifying the owner's name in both the document and the site plan. Ensure the land size and dimensions are correct, and check the licensed surveyor and director of survey signatures and date. Confirm the location of the property. Finally, ensure that the extra site plan is checked and the back of it is signed by the parties. Verify signatures of the parties and witnesses, check jurat for illiterate parties, confirm the solicitor's seal, and ensure the solicitor is in good standing. Lastly, check the oath of proof.